My name is Ed Cook, Senior Legal Counsel with the Legislative Services Agency. This presentation is on redistricting in Iowa. Many people, when they hear the term redistricting, think of gerrymandering, and not in a positive light. And here is a political cartoon from 1812 that spawned the phrase, created by combining the name of the governor of Massachusetts, Elbridge Gerry, with the term salamander. Iowa, however, does redistricting in a different way. Before discussing how Iowa conducts redistricting, it is important to understand certain fundamental legal principles that govern redistricting in all jurisdictions. Many of these key legal principles were established in the 1960s. First, the United States Supreme Court, in a series of cases, established the one-person, one-vote principle as it relates to redistricting. First case, Baker v. Carr, established the principle that legislative apportionment was a justiciable issue and merited judicial evaluation. Following that decision, the court determined that equal population, the one-person, one-vote standard, applied to both congressional and state legislative districts. And for congressional redistricting, a strict equality standard was applied, that districts should be as nearly equal as practicable. In addition, the Voting Rights Act of 1965 has implications for redistricting. Two sections of that act apply. Section 5, which is never applied in Iowa, required Justice Department pre-clearance prior to making election law and redistricting-related changes in selected covered jurisdictions. However, the United States Supreme Court in 2013 determined that the coverage formula for determining which jurisdictions were covered was unconstitutional. Section 2, which prohibits opposing or applying practices or procedures to deny or abridge the right to vote on account of race or color because a person is a member of a language minority group, applies to all jurisdictions, and in the redistricting context, normally relates to vote dilution. The Voting Rights Act, however, has not been an issue for congressional and legislative redistricting in Iowa. The key case which established the test for whether a Section 2 action could apply is Thornburg v. Jingles. And that three-part test, the first part of that test, Iowa does not meet. The minority population in this state is not sufficiently large or compact whereby a majority-minority district could be created. The United States Supreme Court, however, has issued several decisions dealing with population equality for both congressional and legislative districts. So how equal and by what standard should be applied? Before discussing those cases, it's important to understand certain key terms dealing with population equality. The main term, ideal population, is defined as a number equal to the total population of the state or geographic unit to be redistricted divided by the number of districts to be created. Therefore, you can compare the ideal population of a district to the district populations of districts created in a plan. Two key measurements are generally applied. One is called the mean deviation percentage variations, and that is determined by taking the absolute mean deviation of a plan, which is determined by comparing the population of each district in the plan with the ideal population, and taking that difference and divide it by the ideal population for districts in the plan and expressed as a percentage. Another method of determining population variance is the overall range percentage variance. That term is defined here as the absolute overall range for a plan divided by the ideal population for a district and expressed as a percentage. The range is the difference between the most populous and least populous districts in a proposed plan. The key case in discussing congressional population equality is Karcher v. Daggett. In that case, the court held that a New Jersey congressional plan with an overall range percentage of 0.6984% was unconstitutional. The court stated, "We thus reaffirm that there are no de minimis population variations which could practically be avoided, but which nonetheless meet the standard of Article 1, Section 2 of the United States Constitution without justification." Important for that case was this discussion of what variations between ideal and the district populations are justified. What can be justified? And the court noted that any number of consistently applied legislative policies might justify some population variance, including, for instance, making districts compact, respecting municipal boundaries, preserving the cores of prior districts, and avoiding contests between incumbent representatives. The court further noted that the showing required to justify population deviations is flexible, depending on the size of the deviations, the importance of the state's interests, the consistency with which the plan as a whole reflects those interests, and, highlighted here, the availability of alternatives that might substantially vindicate those interests yet approximate population equality more closely. Following the census in 2010, West Virginia redistricted its congressional districts, and there was a challenge, and the United States Supreme Court heard that challenge. The court held that the overall range percentage for the West Virginia plan of 0.79% was constitutional. The court found that the deviation was justified, looking at what was discussed in Karcher, based on valid, consistently applied identifiable state objectives, by not splitting counties, avoiding contests between incumbents, minimizing population shifts between districts. The court noted that no alternative plan with better population deviations met all of the identifiable state objectives. Therefore, the plan that was enacted by West Virginia was deemed to be constitutional. Based on all the cases for congressional redistricting, population equality generally comes down to one requirement: that districts in a congressional plan should be as close to zero deviation from the ideal population for those districts as possible. There is no safe harbor deviation percentage allowable. The requirement is these districts shall be as nearly equal as practicable. The most commonly used measurement of population equality is the overall range percentage variance, essentially that calculation that looks at the most and least populous district in a plan. It is, of course, a case-by-case analysis to determine if the population variance is specifically justified. The deviation must be based on consistently applied and identifiable state objectives. Important in this case-by-case analysis is a determination of whether there are alternative plans that meet the state's objectives with better population deviations. For state legislative districts, the United States Supreme Court has applied a less stringent federal constitutional requirement. The court initially noted that whereas population alone has been the sole criterion of constitutionality in congressional redistricting, broader latitude has been afforded the states under the Equal Protection Clause in state legislative redistricting. Generally, case law has determined that a state or local legislative map with an overall range percentage of less than 10% presumptively complies with the one-person, one-vote rule. But what about Iowa? How does Iowa deal with redistricting? Important here are three key events that shape Iowa's current redistricting process. The first of which was in 1968, when the Iowa Constitution was amended in several ways dealing with redistricting. Subsequent to that constitutional change, there were a series of cases before the Iowa Supreme Court, culminating in a decision in 1972 where the Iowa Supreme Court determined that the legislatively enacted redistricting plan for the 1970s was invalid, using population exactness and establishing certain prohibited factors. Finally, in 1980, the Iowa General Assembly adopted Iowa's current redistricting process, codified in Iowa Code Chapter 42. So what was Iowa's constitutional response in 1968? Several provisions of the Iowa Constitution were modified. Article 3, Section 6, dealing with senators, was modified to provide that the number of senators shall be not more than one-half the membership of the House of Representatives, and they shall be classified so that as nearly as possible, one-half of the members of the Senate shall be elected every 2 years. Article 3, Section 34 was also amended to provide that the Senate shall be not more than 50 members and the House of Representatives shall be not more than 100 members. It requires that each district shall be of compact and contiguous territory, and that senatorial and representative districts shall be apportioned on the basis of population. That section also provides in regards to senatorial districts that the General Assembly may provide for other factors in addition to population to be considered in apportioning those districts, and also establishes a modest population equality standard for senatorial districts. Article 3, Section 37 deals with congressional redistricting. That section provides that when a congressional district is composed of 2 or more counties, it shall not be entirely separated by a county belonging to another district. What that means is congressional districts need to be contiguous. It further provides that no county shall be divided in forming a congressional district. No county can be split in forming congressional districts. Article 3, Section 35 was also amended to provide that the General Assembly shall complete the apportionment of senatorial and representative districts prior to September 1 of the year ending in 1. If, however, the apportionment fails to become law prior to September 15th of such year, the Supreme Court shall cause the state to be apportioned in the senatorial and representative districts. That section further states that the reapportioning authority shall, where necessary in establishing senatorial districts, shorten the term of any senator prior to completion of their 4-year term. Article 3, Section 36 provides for review by the Supreme Court and states that upon verified application by any qualified elector, the Supreme Court shall review an apportionment plan adopted by the General Assembly. If the Supreme Court determines such plan does not comply with the requirements of the Constitution, the Court shall adopt or cause to be adopted a compliant apportionment plan. The section states that the Supreme Court shall have original jurisdiction of all litigation questioning the apportionment of the General Assembly or any apportionment plan adopted by the General Assembly. Following adoption of these constitutional amendments, the Iowa General Assembly was tasked with the requirement of drawing new boundaries for use in the 1971 and 1972 General Assembly. In 1969, the General Assembly established certain parameters for enacting that plan. It utilized a 14-member commission. It was based upon the 1960 Census and provided that the plan would be composed of 100 state representatives and 50 state senators. No voting precinct would be divided and follow counties wherever possible. As a result of that process, the Iowa General Assembly enacted a plan for use in the 1971 and 72 General Assembly. That plan had overall range percentage variances of 12% in the Senate and 14% in the House. Based on the authority of the Constitution allowing for a challenge of an apportionment plan, that plan was challenged and brought to the Iowa Supreme Court. And the Iowa Supreme Court in 1970 determined that the plan had population variances that exceeded those that were constitutionally permissible. The court noted that protection of incumbents and limiting contests with existing members were insufficient reasons to justify those population variances. They utilized the very exacting congressional standard in coming to this conclusion. The court, however, decided to allow the plan to be used for the 1971 and 72 General Assembly, noting that time constraints prevented the adoption of a constitutionally valid plan for the 1970 elections. The court did, however, direct the legislature in 1971 to adopt an acceptable plan for the next decade. And following the census in 1970, the Iowa General Assembly in 1971 did enact a legislative redistricting plan. That plan had an overall range percentage variance of 3.2% in the Senate and 3.8% in the House. That plan was challenged before the Iowa Supreme Court. And in 1972, the Iowa Supreme Court declared that the legislatively enacted plan was unconstitutional on both population and compactness grounds. The court rejected establishing a de minimis population variance standard for districts and noted several impermissible considerations that could not be used to justify population variances, such as protecting incumbents, preserving present districts, avoiding joining part of a rural county with an urban county, avoiding election contests, and ensuring the passage of the redistricting plan. The court retained jurisdiction and drew the plan that was used for the legislature in the 1970s. In drawing the plan, the court utilized the expertise of the Legislative Service Bureau to assist in drawing the plan. And the resulting plan had very low deviation percentages. The overall range percentage variance for the Senate was 0.05% and for the House was 0.09%. In addition, the court determined that all Senate districts would be subject to an election in 1972. But the court, by lot, would determine which of those elections would be for a 2-year or 4-year term. As the 1980 census approached, the Iowa General Assembly enacted Iowa's current redistricting process in Iowa Code Chapter 42. And the remainder of this presentation is going to discuss how Iowa redistricting process works. Iowa's process includes two key elements: redistricting standards and provides for the process of redistricting. The redistricting standards include both absolute and relative standards, and it is hierarchical in structure. The standards are generally described in order of precedence, and objective measurements are provided for the relative standards. So what are the specific redistricting standards? And these are codified in Iowa Code Section 42.4 and are applicable to all levels of redistricting in Iowa. The first standard is population. And the Iowa Code provides for congressional districts that they be as nearly equal as practicable, and that no district shall vary by more than 1% from the ideal population, except as necessary to comply with the whole county constitutional provision. Statute states that the burden is on the General Assembly to justify any district with a variation in excess of 1% from the ideal population. In practice, however, the requirement is much more stringent, that the districts that the LSA will provide for congressional redistricting shall be as close to zero deviation as possible, consistent with the Iowa Constitution's whole county provision. Reliance on what the 1% provision is unwise. There is no safe harbor percentage under the United States Constitution and applicable case law. And case law does support the requirement that each successive congressional plan presented by the Legislative Service Agency have an equal or lower population variance. The Iowa Code also provides for population requirements for legislative districts. Those districts shall be as nearly equal as practicable. The mean deviation percentage variance shall not exceed 1%. The overall range percentage variance shall not exceed 5%. And the burden is on the General Assembly to justify any district with a variation in excess of 1% from the ideal population. In practice, the Legislative Services Agency uses the strictest requirement. No district shall vary from the ideal population by more than 1%. This prevents shifting the burden to the General Assembly to justify water population variances. And it is also consistent with the 1972 Iowa Supreme Court case, which utilized the very exacting population standard for congressional districts for state legislative districts as well. The next requirement under Iowa law is to respect political subdivision boundaries. And Iowa law provides, to the extent consistent with the population standards, district boundaries shall coincide with boundaries for political subdivisions. The number of counties and cities divided shall be as small as possible, and the law provides that you should split the larger political subdivision over the smaller, unless the legislative district line follows the county line and splits the city. In practice, for congressional redistrict, the Iowa constitutional requirement that no county shall be split is followed. And so county lines will be followed and no county shall be split for congressional redistricting. For legislative districts, the Legislative Services Agency follows the statutory requirements. And if a political subdivision is to be split, tries to keep the number of splits of that political subdivision to a minimum. The next requirement under Iowa law is contiguity. And the law provides that districts shall be composed of convenient contiguous territory. Also provides that no point contiguity is allowed, so districts that meet only at a point are not considered contiguous. This is an absolute requirement and is constitutionally required for both congressional and legislative districts. The next requirement is compactness, and districts shall be reasonably compact in form, consistent with the previous standards of population, political subdivisions, and contiguity standards. Compact districts are described as square, rectangular, or hexagonal in shape and not irregularly shaped. The law includes two compactness measurements, and for legislative districts, compactness is constitutionally required. So what are those two measurements? The length-width compactness generally tries to describe whether a district is in the shape of a square, and provides that the compactness of a district is greatest when the length of the district and the width of the district are equal. Perimeter compactness looks at whether a district is irregularly shaped and provides that the compactness of a district is greatest when the distance needed to traverse the perimeter boundary of a district is as short as possible. In visual form, these are how the two compactness tests are utilized: the length-width compactness and the perimeter compactness. The next criteria under Iowa law lists several prohibited factors and provides that no district shall be drawn for the purpose of favoring a political party, incumbent legislator, or member of Congress. The law provides that you cannot use addresses of incumbent legislators or members of Congress, the political affiliations of registered voters, previous election results, and demographic information other than population head counts, except as required by the Constitution and the laws of the United States. These prohibited factors match quite exactly what the Iowa Supreme Court found to be improper reasons for justifying population variances. Another requirement under Iowa law in drawing congressional legislative redistricting lines is that each state representative district shall be wholly included within a single senatorial district. And, so far as possible, each representative in each senatorial district shall be included within a single congressional district. While not a specific line drawing requirement, Iowa law does make provision for Senate elections. And the law provides that each bill embodying a plan drawn under this section shall include provisions for election of senators to the General Assemblies which take office in the years ending in 3 and 5, which shall be in conformity with Article 3, Section 6 of the Constitution of the State of Iowa. As noted, Article 3, Section 6 provides that districts shall be classified so as to keep as nearly as possible the number of Senate elections for a 2-year term in the year ending in 2 to a minimum. Consistent with this constitutional requirement, Iowa law establishes a procedure for determining whether senators elected in a year ending in 0 can hold over and serve a 4-year term and not be subject to another election in 2022. For 2021 plans, potential holdover senatorial districts will have an even number. Based on these two requirements, the LSA numbers Senate districts in a plan to try and limit the number of elections in 2022 for a shortened 2-year term by numbering new Senate districts that contain the address of a senator elected in 2020 with an even number, creating potential holdover senatorial districts. However, this numbering is only done after district boundaries have been established. Political considerations are not allowed in the drawing of proposed districts. But what about Iowa's redistricting process? Key players in Iowa's process are the Legislative Services Agency and the Temporary Redistricting Advisory Commission, referred to as the TRAC. Iowa law establishes the basic parameters of the TRAC. It consists of 5 members, and it shall be established no later than February 15th of the year ending in 1, and so it will be 2021. 4 members are appointed by the majority and minority leaders of the General Assembly, and the 5th member and chairperson is selected by the majority vote of the 4 appointed members. Membership has certain requirements. They must be an eligible elector of the state, hold no partisan office or political party office, and not be an employee or relative of a member of the General Assembly or Congress. Iowa law specifies the duties of the TRAC as well. And the TRAC is to provide advice and guidance to the Legislative Services Agency on certain redistricting matters only upon written request of the Legislative Services Agency. TRAC is also required to conduct at least 3 public hearings and submit a report to the General Assembly on the first proposed redistricting plan. TRAC, however, does not have any access to LSA redistricting plans prior to delivery of the first proposed plan. They do not have approval authority over any proposed redistricting plan, nor do they have authority to direct the Legislative Services Agency regarding requirements for the development plans except upon the written request of the Legislative Services Agency. The Legislative Services Agency created an Iowa Code as a nonpartisan central legislative staff agency under the direction and control of the Legislative Council, and it has a statutory role in congressional, legislative, and local redistricting. The Legislative Services Agency is solely responsible for preparing each proposed redistricting plan, and in doing so, There is no interaction or involvement with the TRAC, legislators, or any outside interest while plans are being developed and selected by the Legislative Services Agency. So, how does redistricting start in Iowa? Before Iowa can begin, certain events at the federal level must occur, setting the stage for redistricting in Iowa. The first key event, of course, is Census Day. The decennial census is required by the United States Constitution and was conducted by the United States Census Bureau on April 1, 2020. Subsequent to that, also required by the United States Constitution, the apportionment of members of Congress are adjusted based on the decennial census, and the United States Code requires that the resident population totals for each state be delivered to the President by the end of the year of the census, December 31, 2020, and within a week, the President shall report the census counts and the number of representatives to which each state shall be entitled. Finally, pursuant to the Census Redistricting Data Program, established pursuant to Public Law 94-171, the U.S. Census Bureau is directed to make special preparations to provide redistricting data needed by the 50 states, and within 1 year following Census Day, the Census Bureau must send to the governor and legislature in each state the data necessary to redraw districts for the United States Congress and state legislatures. And of course, the delivery of this Public Law 94-171 population data to Iowa triggers the start of redistricting in Iowa. Iowa law specifically directs the Legislative Services Agency to use that census data to assign a population figure to each geographic or political unit used for redistricting, and then to begin the preparation of congressional and legislative districting plans. So, what about plan preparation? What are the general requirements and process LSA uses in preparing proposed redistricting plans? The LSA is responsible for submitting up to 3 plans for consideration by the General Assembly. All plans are submitted by the LSA in bill form and are subject to enactment through the legislative process. All plans include both a congressional and legislative redistricting plan. Iowa Code requires this, and the qualified nesting requirement that legislative plans follow congressional district boundaries necessitates simultaneous submission and consideration of both redistricting plans. Iowa law provides that upon delivery of a bill embodying a plan to the General Assembly by the Legislative Services Agency, certain information shall be made available to the public. Copies of the bill, maps illustrating the plan, a summary of the standards used for developing the plan, and population totals and relative deviation from the ideal population of each district created in the plan. So, upon delivery of the population data to the states, the Legislative Services Agency is required to deliver its first plan of congressional and legislative districts to the General Assembly no later than 45 days after that release. For the first plan, the Temporary Redistricting Advisory Commission is required to conduct at least 3 public hearings following release and issue a report to the legislature. And the legislature may not consider the first plan until at least 3 days after the TRAC report has been released. The bill presented must be brought to a vote expeditiously. That is, it continues through the process until rejected by a vote of the entire House, by a vote of the entire Senate, or by veto of the governor. And only corrective amendments are allowed. If the first plan is rejected, the Legislative Services Agency is required to deliver a second plan of congressional and legislative redistricting. And this plan will be delivered within 35 days after the first plan is disapproved. And this plan will be prepared by the LSA in accordance with reasons for rejection of the first plan, so long as those reasons do not conflict with code standards. The House or Senate may, by resolution, adopted within 7 days of the plan's rejection, give reasons for rejection of the plan, and the governor, through the veto message, may also provide reasons for rejection of the plan. And the second plan, once presented, may not be considered by the legislature until 7 days after the LSA has delivered the bill, and, like the first plan, must be brought to a vote expeditiously and continue throughout the process until it is rejected. Like the first plan, only corrective amendments are allowed. You cannot reconsider the rejected first plan. If the second plan is also rejected, the LSA is required to deliver a third plan, and that third plan will be delivered within 35 days after the second plan has been disapproved. It is again prepared by the LSA in accordance with reasons for rejection of the second plan, so long as those reasons do not conflict with code standards. Again, the House or Senate may provide those reasons by resolution, and the governor may provide those reasons pursuant to a veto message. The legislature may not consider the third plan until at least 7 days after the LSA has delivered the bill. However, unlike plans 1 and 2, the third plan is subject to amendment in the same manner as other bills. In considering any particular plan, keep in mind that the most important requirement is population. Specifically, the LSA will provide each successive congressional plan will be of equal or better population variance, will not be worse. Know your options in considering a potential redistricting plan. Each plan release is considered by the LSA to be the plan that best meets the criteria at the time of release. There is no requirement that a successor plan be different. For example, don't assume that a better congressional plan may exist. Finally, the standards apply to all the plans. No new standards can be created. The legislature or governor cannot create new standards beyond those required by the Constitution and statute through the resolution or veto message rejecting a plan. Keep in mind that the 1972 Iowa Supreme Court case rejecting a legislatively enacted plan severely limits acceptable non-population redistricting standards in drawing a proposed redistricting plan. So, are there any deadlines for completion of redistricting? The Iowa Constitution provides a deadline for the General Assembly's adoption of a proposed redistricting plan for the legislature. Article 3, Section 35 directs the Iowa Supreme Court to develop a redistricting plan for any General Assembly. If the General Assembly fails to pass an apportionment plan by September 1 of that year, it becomes law by September 15th. There is no such constitutional directive for the Iowa Supreme Court to develop a congressional redistricting plan if the General Assembly fails to act. Finally, keep in mind that Article 3, Section 36 of the Iowa Constitution provides the Iowa Supreme Court with original jurisdiction to review an enacted congressional or legislative redistricting plan, and if the plan is challenged and struck down, to adopt a valid apportionment plan. So, once a congressional and legislative redistricting plan exists, what happens next? Of course, local redistricting commences once this is completed, and generally the Secretary of State is primarily responsible for local redistricting. LSA, however, is statutorily required to develop proposed Plan 3 county supervisor districting plans. So those counties that elect supervisors by districts, the LSA will be required to draw prospective redistricting plans for that county. Furthermore, adoption of elections under the new map will first occur in 2022. In particular, events occurring subsequent to the adoption of the legislative plan will help determine which Senate districts will hold an election in 2022. Senate elections are dependent on whether district number is odd or even. And odd-numbered districts had elections in 2018 and will have elections in 2022 for a 4-year term. Even-numbered districts had elections in 2020 and will have elections in 2024. But keep in mind that newly adopted redistricting plan is effective for the General Assembly terms beginning in 2023 and applies to 2022 elections for that General Assembly. Redistricting impacts the standard election year cycle for senators by occurring just 2 years after an election for half of the seats in the Senate, and by inevitably changing the boundaries and numbering of senatorial districts. How does one handle the 2022 Senate elections? The Iowa Constitution permits the shortening the term of any senator if necessary when establishing new senatorial districts, but Iowa law does not mandate an election in every senatorial district for the next general election cycle following redistricting. And Iowa law provides that certain Senate incumbents shall be allowed to continue serving for a 4-year term without being subject to an election during the first general election following redistricting. For odd-numbered Senate districts, a Senate election will be required in 2022 for a 4-year term. And all incumbent senators located in an odd-numbered district in the new plan are required to seek election in 2022, even if they were elected in 2020. No senator is entitled to a 6-year term. Even-numbered Senate districts, designated as a holdover senatorial district for 2022, will have an election in 2024 for a 4-year term. Senate elections, however, may be required in 2022 for a shortened 2-year term. And so an important consideration is which even-numbered Senate district will require an election in 2022 for a 2-year term. And the determination is based upon Iowa law in Iowa Code Section 42.4. 2 key deadlines are utilized in determining whether an election for a certain Senate district will be required in 2022. On February 2nd, 2022, the first Wednesday in February, each incumbent senator shall declare their residence as of this date by filing a form with the Secretary of State. The resident shall be within the district from which the senator was last elected. February 16th, 2022, the third Wednesday in February, each incumbent senator may resign from office by that date, effective no later than January 2023, by filing a copy of the resignation with the Secretary of State. So when is an election required for a shortened 2-year term in 2022? If no incumbent senator resides in a new holdover or even-numbered senatorial district as of February 2nd, 2022, then an election for a shortened 2-year term for that new Senate district will be required. If at least 2 incumbent senators reside in a new holdover or even-numbered senatorial district as of February 2nd, 2022, and they have not resigned from office effective no later than January of the following year, by February 16th, 2022, an election for a shortened 2-year term will be required for that Senate district. In addition, even if only 1 incumbent senator who has not resigned resides in a new holdover senatorial district, an election may still be required if the requirements to avoid an election in 2022 are not met. And so what are those requirements where an election is not required for a shortened 2-year term? If only 1 incumbent senator who has not resigned as of February 16th, 2022, and who was elected from a district requiring an election in 2020, is resigning in a new holdover senatorial district as of February 2nd, and the senatorial district in the new plan, which includes the place of residence of the state senator on the date of the senator's last election to the Senate, is the same as the holdover senatorial district in which the senator resides on February 2nd, 2022, or is contiguous to such holdover senatorial districts. In that situation, an election will not be required, and that senator who was elected in 2020 will be able to serve a 4-year term and not be subject to a new election until 2024. So what has happened under Iowa's redistricting process since its adoption in 1980? Since its adoption, the plan presented by the Legislative Services Agency has been adopted. In 1981, the third plan presented by the LSA was adopted without amendment. In 1991, the first plan was adopted. In 2001, the second plan was adopted. In 2011, the first plan presented by the LSA was adopted. In all cases, no enacted congressional and legislative plan under the process established in Iowa Code Chapter 42 has been challenged in court. This slide provides population statistics for each congressional plan adopted since 1981. As is apparent, in all cases, the plans submitted by the Legislative Services Agency and approved by the General Assembly had minimal population deviations. Each plan had an overall range percentage variance of less than 0.05%. This slide provides population statistics for each senatorial and representative legislative district of a plan adopted. In all cases, no district exceeded the ideal population for that district by more than 1%, and the overall range percentage variance for all plans was less than 2%. This slide demonstrates the impact of drawing congressional and legislative district boundaries without regard to political considerations by showing the number of incumbents paired in each adopted plan. As one can see, in each cycle, members of Congress, the Senate, and the House have been paired in the plan adopted by the General Assembly. For further information about Iowa's redistricting process, one can look on the Iowa General Assembly website. Under About Redistricting, there is general information about Iowa's redistricting process. Another link, Iowa Redistricting, provides plan year specific information. This concludes the presentation on Iowa redistricting. Thank you.